proceed. I don't know which part of my introductory remarks got lost. Anyway, there is no question of going back. I am going to be here till the last moment of the session. So please go ahead.
Right. So thank you, Mr. Sajid Kumar, for your introductory remarks. Now this session, most of you might not be in the inaugural session today. In the inaugural session, we started with a discussion on insolvency and entrepreneurship. And the reason being, in the long title of the code, the objective is mentioned as the objective of the code is to promote entrepreneurship also. And the chairperson provided an exquisite view upon how these seemingly contradictory aspects of insolvency and entrepreneurship are not so contradictory after all. And there is certainly a great semblance of sense and coordination, and certainly what we desire to achieve. Most of our experts also know, that the nomenclature of this symposium, insolvency, restructuring, entrepreneurship, is also a course that we have been co-teaching, and there has been a lot of discussion. And one of the inspiration was Professor Douglas Cumming. The first article that we read was by Professor John Harner and Douglas Cumming, and that gave us some inspiration how to proceed in that direction. But certainly now I would want to invite first Miss Antonia Menzies, and she would want to present the view of the World Bank on how they want to promote the resolution in MSME and promoting entrepreneurship, and what is the how does the World Bank, the IFC, support economies in this process?
Thanks very much, Dr. Garg. Will someone upload my presentation? While it's being uploaded, maybe I'll just start in the interest of time. Good evening to everyone. It gives me great pleasure to be here today. As Ria said, my name is Antonia Menezes. I'm a senior financial sector specialist in the World Bank Insolvency team. We provide advice and assistance to governments to reform their insolvency regimes around the world. I thought that as a first step, it would be good to remind ourselves that insolvency regimes play a market efficiency role. Their purpose is to filter viable businesses that should remain in the economy from non-viable entities that should exit the market as soon as possible. One of the work streams that the World Bank Insolvency team has is to collect empirical evidence and academic research that shows the effects of strong insolvency regimes on economic growth. The governments that we work with often ask us to show quantitative evidence, so actual numbers, as opposed to anecdotal or qualitative evidence that insolvency regimes can impact the economy. And we now have evidence that strong insolvency regimes increase returns to creditors. This lowers creditor risk. And again, we have evidence showing that this in turn allows the cheaper pricing of loans and more widespread access to credit, which encourages more economic activity. Related to our discussion today, effective personal bankruptcy systems that allow for the better protection of natural person entrepreneurs, such as sole proprietorships, are associated with increased levels of entrepreneurship and increased number of startups in the country. So I was hoping, I don't know if my slides can be shown. I was hoping to show you examples of the data that we have collected.
Ms. Antonia, for some reason your slide is not available in the email that you shared. If you could just reshare it with me. I'll take just 30 seconds to upload it, or you could share your screen if that's possible.
Yeah, let me just try and do that.
Yes. I'm so sorry for the inconvenience. Is this? Yes.
Yes. So if we can go forward 2 slides, please.
Right. So no, never mind. I'll try to. Okay. Yeah.
Next slide, please. So this gives you an idea of the kind of data that we collect. You can actually go to our website and see examples of the models that we run and the studies that we have collected from various academics and economists. But what you see here is domestic credit to the private sector as a percentage of GDP on the x-axis, and that data is taken from the World Bank development indicators, and then recovery rate as cents on the dollar on the y-axis. That's from the Doing Business report. And what we see is that there's a positive correlation between creditor recovery and the availability of credit. So the higher creditor recovery, the more credit is available to businesses to access. Next slide, please. We also collect empirical studies showing insolvency reform can strengthen the availability of credit. So this was a study undertaken by Funchal et al. In 2012, and it examined the effects of amendments to the Brazilian bankruptcy code in 2005. And what it found was that there was a statistically significant increase in the Brazilian private credit market after the reform, with a 10% to 17% increase in total debt and a 23% to 74% increase in long-term lending. Next slide, please. We also have empirical studies showing that insolvency reform can increase creditor recovery. So a study by Gamboa, Cavazos, and Schneider looking at the amendments in Mexico to the new corporate insolvency law showed that there was an increase in average recovery rate for secured creditors from 19 cents on the dollar to 32 cents on the dollar, as well as a shortened duration of proceedings from an average of 7.8 years to 2.3 years. Next slide, please. We also have several studies showing a connection between a country's personal insolvency law, which applies to unincorporated entities such as sole proprietorships and partnerships and entrepreneurship. So for instance, Fan and White in 2003 undertook a survey of 20,000 families in the US. And what it showed was that there were more entrepreneurs in states with higher asset exemptions. And I believe some of my fellow panelists will be discussing their research and data in more detail. Next slide. Of course, the pandemic is having an effect on businesses, from large corporates to micro and small businesses and individuals. A lot of commentators believe that we have not yet seen the full effects of the pandemic on businesses, given that many countries are putting emergency measures in place, and Saji just mentioned the changes to the IBC and the suspension. But given that these countries are putting emergency measures in place to flatten the bankruptcy curve and prevent an influx of cases, many commentators think that once the stimulus and forbearance measures end, that is when we will see a significant increase in bankruptcy filings. Next slide, please. However, what is clear is that MSEs, micro and small enterprises, are being particularly affected by the crisis. So, for instance, the IMF predicts that SME bankruptcies could triple from an average of 4% before the pandemic to 12% in 2020. An OECD policy response paper, which was written in April, reports that at that time, commercial court data from France showed that 72% of companies with fewer than 5 workers and 51% of companies with a turnover of under 500,000 euro are now at grave risk of financial collapse. Can we go to the next slide? And the one after this, please. Even before the pandemic, the World Bank was focused on making insolvency regimes easier to access for micro, small, and medium-sized enterprises, MSMEs. These enterprises employ more than 1/3 of the world's total labor force and generate economic value representing about 52% of private sector value added globally. And we estimate that before the pandemic, there was a $5.2 trillion funding gap for formal MSMEs and a $2.9 trillion funding gap for informal MSMEs. Next slide, please. So this slide lists many of the challenges that MSMEs face. Of course, not only in emerging markets, but in many countries around the world when trying to access insolvency regimes. And in the interest of time, I won't go through them, but generally MSMEs do not access insolvency frameworks because of their complexity, cost, and lack of understanding about the framework. Often MSMEs have insufficient assets, and so creditor passivity is a huge problem where creditors just do not engage in the process. It's just not worth their time. And so they prefer to take write-offs. And as I showed in my earlier slide, lower recovery impacts the pricing and availability of credit, which in turn affects how many businesses can actually enter the market. Next slide. I think some of you know that the World Bank is the standard setter together with the United Nations Commission on International Trade Law in insolvency. So we set best practice standards for countries' insolvency regimes. The instrument that the World Bank uses for best practices is called the Principles for Effective Insolvency and Creditor-Debtor Regimes, and you'll be able to find these on our website. And we will be issuing new principles in the next month or so, which has specific standards for countries designing insolvency regimes for micro and small businesses. Next slide. I won't go into the slide in the interest of time, but again, you can find all our reports and background research on our website. Next slide. And the next slide, actually. I'll skip forward to the next one. What we've seen is really two options. Countries either modify their existing insolvency law, so often the company's law or the personal bankruptcy law, to put procedures in place that facilitate the insolvency and discharge of businesses, or they have standalone specific processes for MSMEs. And these are just some issues that I wanted to emphasize. As I say, our new principles are forthcoming. But our principles apply to micro and small enterprises, not medium-sized enterprises. Although it's very difficult to find data, our assessment was that medium-sized enterprises in most regions of the world are capable and do not face huge obstacles in going through the normal insolvency framework. We don't take a position on whether countries should amend separate insolvency laws or have a single standalone bespoke insolvency law specific to MSMEs. We do recommend that the provisions put in place should be specific to MSMEs regardless of legal form, so whether sole proprietorships or corporates. The procedures should be convenient, inexpensive, and easily accessible, and there should really be a focus on minimizing procedural formalities. There should be an easy conversion from reorganization to liquidation. We recommend that reorganization plans should still have a vote by creditors with approved majority thresholds, as is the normal standard in most insolvency laws, but that the debtor should remain in management for reorganization. There should be a discharge of good faith natural person debtors, and this is central to our principles. It's one of the major obstacles we've seen around the world with stigma and making it more difficult for entrepreneurs to enter and exit the market. And finally, there should be supportive institutions, and we're currently doing a lot of work in helping institutions scale up their support to MSMEs. So I'll stop there, but please let me know if you have any questions. Thank you.
Right. Thank you, Antonia. That was quite exquisite presentation and very lucidly explained. I'm sure the regulator is listening carefully and they have their working groups where they have been, discussing these issues. So, in continuation, now I would like to invite Professor Douglas Cumming to share his empirical-based study on relation between the insolvency and entrepreneurship.
Great, thanks very much. Can everybody hear me?
Yes, fine.
Excellent, and hopefully my screen sharing is working. Great. Okay, so that was a great presentation on the updated insolvency laws. I think a really good look at the importance of insolvency for entrepreneurship and innovation. And I thought what I would do today with this generous allocation of time is talk about some of the work that we've done over the years in terms of measuring international differences in insolvency law and how it relates to three interrelated issues of firstly measuring entrepreneurship, so the impact of insolvency law and entrepreneurship, and then secondly venture capital, so one of the main forms of financing innovative entrepreneurship, at least for high growth enterprises. Should clarify that most companies will not be receiving venture capital around the world. So it's not the dominant form of finance, although for more successful companies, they often are financed with venture capital. So it's a much more common form of finance for the more innovative and likely much more successful companies around the world. And then the more recent project that we've engaged in is to look at angel investment around the world. And that's a much harder angle because angel investment is harder to track. The data are more difficult to obtain in the context of angel investment. An angel investor is different than a venture capitalist in the sense that a venture capital fund is arranged as a formal financial intermediary. So a set of professional fund managers set up an investment vehicle, normally as a limited partnership in most places around the world. And that limited partnership has a 10-year lifespan where institutional investors contribute money to a fund. They make a capital commitment to a fund, and that money is invested typically within a 5-year period, and then the investments of the fund are typically wound up within a 10-year period, although it might extend for another 2 to 3 years subsequent to that 10-year horizon that's normally put in place. So that's the structure of a venture capital fund, as a formal financial intermediary and run by professional investors. Angel investors, by contrast, are rich individuals, individuals that have typically been successful entrepreneurs in the past. And instead of investing in publicly traded companies or other investment vehicles, they like to, if you will, get their hands dirty with getting directly involved in the next generation of entrepreneurs by investing directly into their businesses. And they're sometimes, or I should say more often than not, at an earlier stage than venture capital. So angel finance might come at the same sort of development stage of a company as venture capital, but it's often coming at an earlier stage for more nascent entrepreneurs. And nevertheless, an extremely important stage of finance, and very important to foster successful angel investment, to have a successful entrepreneurial sector. And so these three complementary things, I'll just give you an overview. And this work originated with John Armour, law professor at Oxford, and he and I first sought out to codify international differences in personal bankruptcy law. And when we did this originally, just as a backdrop, many people had asked us, why personal bankruptcy law? Why not corporate bankruptcy law? Isn't that more important for starting a business and being an entrepreneur? And there have been, much discussion of this topic over the years normally in the law literature and in law reviews and the like. And what is the prevailing view in that literature is that entrepreneurs, even if they set up a company and have limited liability protection, to arrange finance at a very early stage, given the risks that are involved, it's commonplace for entrepreneurs to have to make personal guarantees on their formal obligations that they undertake in raising external capital. And so those personal guarantees become quite important vis-a-vis personal bankruptcy law. And likewise, just through running through a number of cases, you see entrepreneurs, if you will, bootstrapping their business, using credit card debt and other things to get off the ground. And so really, it's the widely held prevailing view that personal bankruptcy law has a much more direct connection to entrepreneurship than other, than corporate bankruptcy law or even other legal changes around the world. And when we first took a look at this, we had some pre-existing U.S. evidence to look at. Michelle White, professor in San Diego, published an influential paper in the Journal of Law and Economics looking at U.S. state-level differences in bankruptcy law and seeing a correlation with entrepreneurial activities. I should say, however, that evidence has had mixed support over time. And so even a more recent look at that evidence in the same journal, in the Journal of Law and Economics, has shown that things seem to have changed over time, and that it's that connection is much less stable than what we had previously thought. And so our interest was, if you will, developing a more broader international perspective. Particularly at the time we looked at it, we had seen some changes in bankruptcy law across countries that we sought to codify empirically in order to assess the impact of these changes in a causal way on entrepreneurship, venture capital, and angel investment. And so the main issues that we looked at was the availability of discharge, minimum capital requirements to start a business, exemptions, disabilities, and composition. And I'll go through and explain a little bit how we decided to codify these things, because there's always a worry when you're doing empirical work that someone has a concern that you created an index with p-hacking, if you will. So in other words, you create an index, and then someone says, well, I don't know that my index gave me, so let me change the way we created the index. And as best as possible, I would hope to encourage you to think that we did not do that in this case. We felt that we had some reasonable measures, and doing it across a variety of different countries and methods, and different legal changes, that we could demonstrate that these things are quite robust and showing some causal impacts. So this first index on discharge relates to concerns from pre-bankruptcy indebtedness that's available for an entrepreneur who is either trading as a sole proprietor or guaranteed debts of a closely held company. And so the first question is discharge available. That is the easiest one to codify. If not, then it takes a value 0, and then if yes, then we codify the value 1. And so you see that over time, with some of the countries, that there have been changes over time that we could examine empirically and assess the causal impact. And the reason why these changes over time are so important is that if there haven't been any changes over time, then a regression analysis is just going to be picking up cross-sectional variation. And the ability to, infer some sort of causal impact is much, much more limited with a cross-sectional variation. And so we want cross-sectional and time series variation in order to assess any causal impact. And when we did these indices, so I'm showing this from our original work back that was published in 2008 in the American Law and Economics Review. And, some of these indices have been extended up until current day, as I'll talk about in our more recent work on our angel investment paper. But these are for the tables from our original work, and I'm showing you how we codified them. So our second measure here is discharge years. So if discharge is available, then, how useful is that for the remainder of your life? So in some countries, the remainder of life is much different than others, and so we came up with this alternative measure for how many years that could be useful for a particular entrepreneur. So the second one on minimum capital and exemptions. So minimum capital, how much capital does it take to start a business, a form of private company? So we felt that was certainly pertinent to include and show that indeed as well across countries and over time there have been changes. Exemptions, this relates to pre-bankruptcy assets that are exempted from the bankruptcy estate. So this is trickier to codify. So as we explain here, we have the value one if exemptions from assets from the pre-bankruptcy estate only cover personal items, tools of trade, etc. Takes 0 if exemptions are more generous, and takes 2 if exemptions are negative. So for example, a spousal property can be pulled into the estate. And again, you see some cross-sectional and time series variation for the countries that we codified these for. And the last two have to do with disabilities and composition. So disabilities are restrictions on the debtor's civil and economic rights related to bankruptcy. So it can range from 0 through 4. So 0 if no disabilities other than loss of power to deal with assets in a bankrupt state. 1 for civic disabilities, 2 for economic disabilities, 3 for interference with mail and travel, and 4 for incarcerated for non-payment of debts. And so, for instance, in early years, you wouldn't want to be a bankrupt person in Greece, for example. And then composition relates to the possibility of agreeing to composition with creditors as a means of terminating an existing bankruptcy proceeding. And so in this case, we created a formula that considers the proportion of the face value of existing creditors' claims and the proportion of the number of creditors who must vote in favor to effect a compromise. And so, again, what we did is we went through all the pieces of legislation because nobody had created an index like this before, and we codified these rules cross-section and over time, and we wanted to see if they matter and do that in a regression setting. Firstly, with using at least as best as possible an econometric setting to ascertain causal impacts. And so we set it up as a panel data, meaning that there's cross-sectional and time series variation. To account for other things being equal, we use country fixed effects, meaning that the way we say that econometrically is that we have dummy variables in each of the countries to account for unobserved heterogeneity across the countries that might otherwise explain these differences. And then we run what's known as a difference in differences estimator, looking at the impact of changes in one country while there are not similar changes in other countries. And what you see with the empirical evidence looking at self-employment per population as our measure of entrepreneurship. I should say that's not the only measure of entrepreneurship. It's at least one measure. Certainly well accepted, but there are other measures that could be put in place, as I said. And the data are quite unambiguous in highlighting a role of bankruptcy law changes and spurring on self-employment. And so if you compare the economic significance, so the statistical significance is very large. So it's statistically significant at the 1% level, meaning there's less than a 1% chance of our making an incorrect inference that bankruptcy law changes matter for entrepreneurship. And the economic significance is that this is increasing, these changes are increasing this rate of entrepreneurship by close to 10% relative to the average level that existed prior to these changes. And here I've just shown you one regression table. We put many of these tables and other robustness checks in the paper, but here we've controlled for our country fixed effects, time to discharge, GDP growth, for instance, stock market conditions, tax variables, time trends, etc. And this quite shows up as being quite robust. I know I don't want to take up too much time, so let me speed up a bit. The second project that we had done was published, as it turns out, a little bit before the first. We looked at venture capital, and in this case, likewise found significant evidence. These changes facilitated a roughly similar impact. Here I put in as a different way to express it. Say if you're looking at the German situation where it was quite draconian prior to the change, and then they made this more friendly bankruptcy leniency change, and it increased venture capital in a causal way in Germany by about 5.5% for early stage venture capital, benchmarked by GDP to make it comparable across countries. And again, a similar type of regression framework. And then lastly, let me tell you about one final project. This is one that we've been working on for a while. It's published just in late 2019 in the Journal of International Business Studies. And in this particular project, we had obtained angel investment data around the world, and our data was tough to assemble. So angels, don't want to be found. In fact, the one for entrepreneurs, one way to signal to angels that you're a good entrepreneur is you actually figured out who they are. And so as an econometrician, that makes life particularly challenging. And so what we're able to do is get an international angel investment data set by through a company that has been tracking these investments through securities filings. And that company is called PitchBook. And they have what we think is a really good international data set, although there are always issues with gathering angel investment data. But having kept that in mind, we examined various regulatory changes, looking at quite recent data, even updating our bankruptcy law index to recent times. And what we observed, and just in a nutshell, and I don't want to take too much time in the numbers, but what we observed is that, regulatory changes that, for instance, impact the exit environment, such as prospectus disclosure, were particularly important, but not regulatory changes having to do with bankruptcy laws. So we don't see much of an impact of bankruptcy laws on angel investment. And as I say in this summary slide, that there are two possible explanations for this. One is that there are data quality issues that we can't completely discount, although we think we have the best data that exists around the world. Another explanation that we offer in the paper is that angel investments are much more sensitive to international, cultural, and economic conditions. So way more sensitive, for example, as when you compare to venture capital. Venture capital is much different as a intermediary investment compared to angel investment. But nevertheless, the legal changes for securities regulatory changes do seem to matter for angel investment. The bankruptcy evidence certainly matters for entrepreneurship and venture capital. Hopefully I didn't take too much time. Thanks very much. And I'm going to stop sharing.
Thank you, Professor Douglas. This was a really exquisite presentation. Now I would request Professor Rebecca Perry to commence her presentation on insolvency and the digital.
I'm just finding my slides. It can take a little while for these to appear. Okay, now have the slides appeared? Or are you getting a loading signal?
Yes.
It does take a little while sometimes for them to come up. Right, so the presentation I've got is on insolvencies and digital economies, and it's intended to highlight the importance of digital economies, and in particular looking at the perspective of important developing countries. A lot of the rise in economy recently has been down to digital economies, highlighting that in India, information technology has been a significant contributor to the Indian economy, representing a growing 8% of GDP in 2017. There'll be familiar activity through exports and outsourcing, and this has had a great impact on jobs, increasing from 8 million in 2008 to 12 million in 2017, and those figures can be expected to rise further. Other developing countries, it's been important as part of China's economy. In Pakistan, it's been transformative for Bangladesh, and it's also seen as an opportunity for Nepal, one of the poorest countries. The Digital Nepal program it is hoped will enhance a growth in GDP in the next couple of years. So it's something that it offers significant transformative potential for developing countries, and it's also an area in which there's been great entrepreneurship in recent years. So we'll be familiar with many of the names involved in that, but it's something that countries can exploit, in particular countries with large numbers of young people who are skilled in information technology. Because it's a supranational area of activity, those skills are marketable, and there's lots of opportunities there. Nonetheless, from a legal perspective, digital economies do present a number of challenges. The fact that they've got this supranational nature is one. Also, technologies can present us with challenges in the form of new concepts or new types of property that don't necessarily fit with existing legal systems, and I need to rethink sometimes the nature of concepts that we'll be familiar with. Also, something I wanted to highlight is the potential lack of understanding sometimes of what people are dealing with in terms of technologies. I'll discuss this in relation to cloud computing, but we can also see evidence of that in relation to things like cryptocurrencies. And there can be a failure sometimes to appreciate the risks that are entailed. Also, issues as to the sustainability of market players. I'll come on to that in a minute. And also something quite notable is too big to fail potential in a market where some aspects of the digital economy are concentrating around a very small number of companies. And if one of those was to fail, the impact of that could be systemic. It could be as significant as the failure of a bank, given the amount of information and resource which is trusted to these major players. So looking at these issues in a little more detail. First of all, the supranational nature of these businesses will present issues that must be considered from a regulatory perspective. Is legislation needed in relation to particular aspects of the digital economy? But also, because these are supranational businesses, can they be enforced against these companies? Supranational businesses were mentioned in the previous cross-border insolvency panel, but in the presentation by Som, and he highlighted cruise ship companies and airlines and mentioned the issue that these can do business in a country without necessarily having a business incorporated there. So it can be the same issue, for example, in relation to a cloud computing company. There may not be any company incorporated in the place where it does business. There may not even be assets. And looking at insolvencies, if one of these companies was to fail, given that they're supranational, you'll have conflict of laws issues that will need to be figured out. So I'm just dealing with these issues fairly briefly and at a quite high level. It's something that we'll be working on in this year, looking at these issues in more detail through discussion with people from the technology side of things, because some of those concepts can be quite difficult to grasp from a technical point of view. But also from a legal point of view, there's a need to think how the digital economy and how the different aspects of it fit within existing legal concepts, such as property and also issues like liability, where systems will have grown up with two parties, one the claimant or plaintiff, the other the defendant. But in a decentralized system, how does that fit within existing systems of liability? Then these are issues that must be grappled. There can also be a potential lack of understanding of some of the issues. Things like blockchain and smart contracts are very difficult for individuals to get to grips with. Similarly, cryptocurrencies. And just picking up on one example of that, which is cloud computing. So as far as cloud computing is concerned, most people may have an idea of cloud computing as a cartoon cloud that you might see on a weather map, and it being something that floats in the air, and you can't touch it, like a cloud in the sky. But in fact, it just means that data is stored off-site. It still is stored somewhere on the ground in a server that's hosted by another company. And those companies have the potential to become insolvent. And if that happens, then there are difficult issues presented because customers need to recover their data. I'll get back to that towards the end. So looking at it from the perspective of developing countries, one issue is sustainability. And if these systems are to grow with the best potential, there needs to be a legal framework to support that, so that there can be confidence among people who would use those services. And as well as having good technical approaches to sustainability, it would be necessary to have effective things like corporate governance principles and also insolvency laws that would provide as much certainty as possible as to what would happen in the event of a service provider failing, for example, a cloud service provider. And then also in the modern context, obviously, technology's become particularly important in the last year. We wouldn't be having this conference probably in this format had it not been for COVID-19. And technology offers huge advantages. For example, somebody can have a virtualized desktop at home so that what they work on at home is the same as what they would be working on at work. But that does present cybersecurity issues, greater vulnerabilities potentially, and companies need to be vigilant to try and prevent problems. So far as insolvencies are concerned, there are lots of companies that will be involved in something like cloud computing. You would have different aspects of service being provided by different companies, and you can have complexity there in trying to work out where things are in the context of an insolvency. But at the other end of the scale, you've got a large number of businesses, well-known names, and this too big to fail potential. This has been picked up on by the insurer Lloyd's of London in their report Cloud Down, and they found that as more companies rely on the cloud to operate, a select few providers have come to dominate the market. This reliance on a small number of companies creates the potential for systemic risk for service users. So you might consider that the risk of failure is remote, but it's still a significant one, and the impact would be huge. The issue there may well be one of competition law, and we may well see something happening about that in due course. But it's something that needs to be on the radar of regulators. Just turning briefly to the issues in insolvency, and I mentioned earlier this tension that there can be at the heart of insolvencies in digital economies. If the debtor is providing a service to customers, customers are going to want that service to continue while they can find an alternative. They're not going to want the debtor to be immediately shut down, because that could cause loss of important economic activity and data. And so you have this tension at the heart of insolvencies, that customers will want services to continue, but creditors will not want that, because the costs will deplete the sums available for them. And this is something that insolvency systems need to grapple with. In particular, some system where there can be a collective way for customers to share the burden of keeping businesses running, potentially. So just some brief conclusions, and as I mentioned, not dealt with any of these issues in a lot of detail, just highlighting some of the points that need to be considered. the conclusion is that this is an interdisciplinary problem. It needs expertise in technology, obviously a very complex area, and also law, another complex area, to devise a suitable legal infrastructure. And a country that has that in place can market that. That this is a good destination for digital economies and provision of services that is backed by a sound legal infrastructure. And I think if that can happen, there is even better transformative potential for developing countries. Okay, finishes my presentation.
Right. Thank you, Professor Rebecca. That was, certainly it was very lucid and very interesting technological approach. And you are right. It requires a considerable expertise in technology and certainly law. And I'm sure going forward is the era of multidisciplinary approach. And we look forward to your encouragement and similar research. And I do appreciate your support to this symposium. I'll now invite Professor Scott Pryor to make his presentation on the Small Business Reorganization Act of US, which is like a similar to the India SME or the MSME insolvency law.
All right. Well, thank you, Risham, for that opportunity. Let me get to my slides here if I can. I'm not seeing them where I expected them to be. Of course, we always seem to have trouble with this, but I have it on my laptop here, but I don't see it appearing immediately for any of you. So
it might take 10 or 12 seconds, but I'm sure.
Share doc, yeah, that's part of it is the browser here I'm using. Switching from one to another has proved more daunting than I would have expected. So let me try one more thing here to make that happen. I have to admit that my slides are neither the in-depth data that was shared with us by two of our earlier speakers, so I can, I believe, summarize fairly cogently what I was going to say. But in any event, I do want to express my thanks to the entire program here, to Risham, of course, for his organizational efforts, and to the funding organization, UNCITRAL, and others, because this is a very timely topic, and it's one that I believe will produce significant dividends as we go forward, especially as we look forward to the post-COVID system that we are going to have. And again, I'm called to action here. To the share screen and being unable to share the correct screen, and that's greatly to my disappointment here. So I think I will just go ahead here without sharing any additional slides. I apologize for that very much. I think it is the fact that I used the new Microsoft Edge browser rather than the Chrome browser, which seems to work better with a lot of these things. But in any event, most of you know, and if you were part of the earlier presentation of my my law school dean, former bankruptcy judge Rich Leonard, observed that most of the rest of the world finds the debtor in possession model of the United States bankruptcy law, the Reorganization law, or Chapter 11, to be a great compliment and a surprise, if not an open invitation to looting by promoters as they reorganize in a way which will benefit themselves and not creditors. That is not the case. We have within the bankruptcy system that we have Chapter 11 a large number of what we call checks and balances. That is that the bankruptcy judge, limitations on the power of the debtor in possession, the presence of a significant creditors committee, as well as other forms of check, including the administrative office of the United States Trustee. The United States Trustee does not operate as a resolution professional or a trustee in an operational sense. However, it very closely monitors the work of the debtor in possession to ensure that no such dealing is being undertaken. Well, the system that has the debtor in possession model and multiple checks and balances is therefore very cumbersome. Yes, thank you very much. Perhaps we can owe this to Ria here for making this come to pass. So although we can move to the next slide if that's possible to do that. So we have a system that has a debtor in possession model with many checks and balances, the net effect of which is to increase the time and expense and complexity of the bankruptcy process. And that's the problem. When we're dealing with small size enterprises, the very complexity of the process itself, it costs too much, has too much delay, and makes it effectively unavailable to small businesses. To be sure, the small entrepreneur has the opportunity in the U.S. system to file an individual bankruptcy and be discharged of his or her personal obligations. And with regard to micro enterprises, that is all I think that would be necessary. But when we get to small enterprises, although it's the case that the entrepreneur, him or herself, may be able to relieve him or herself of debts, it is the case that the small business itself will not survive. And as we have heard, the data suggests that small and medium-sized enterprises account for a significant portion of economic activity across the global spectrum here. So if we could advance a couple of slides here, it might be useful to get to the problem as identified within the bankruptcy code itself. So if I could make that happen. If not, we're going to talk here. I'm briefly, in fact, let's move ahead to 2 slides at this point to get to the problem that we face. That is, as it was mentioned, that if we have any bankruptcy system, there has to be some check by creditors. It cannot simply be done by a debtor in possession or even a bankruptcy judge. Rather, there has to be creditor input, creditors who are most able to evaluate whether a plan of reorganization is ultimately going to be successful. And in the U.S. system, that involves a plan, which can be quite lengthy, a disclosure statement, which looks like a rights offering with a prospectus with regard to a public issuing of shares of stock, and then ultimately voting by classes of creditors, classes that require an affirmative vote of creditors holding 2/3 in amount of the debt of that class and more than 1/2 in number of individual creditors. All of this works quite well for large publicly traded corporations and even medium-sized enterprises because it provides a means by which the creditors can exercise their prerogative to approve or disapprove of the efforts of the debtor in possession, propose something that's going to benefit creditors and other stakeholders going forward here. And advance the next slide if you would. But for small enterprises, that simply is ineffective. It's too expensive, too time-consuming, and the final thing here, if we can move forward to another slide, I want to talk about the phenomenon of what we call cram down under the United States Bankruptcy Code. So approval of the bankruptcy plan requires satisfaction actually of 16 requirements. Many of them are pro forma, but as we see here on this slide, at least one impaired class must have approved the bankruptcy plan. Well, that means that a single class of creditors can vote against a plan and thereby hold up confirmation unless the debtor in possession proceeds to confirmation under the next subsection of our bankruptcy code, 1129B. So if we could advance the slide there, I would appreciate reference to that because 1129B is commonly known as cram down, and it permits the confirmation of a plan over the objection of dissenting classes of creditors, not merely individual dissenters. Of course, there will always be those, but over a dissent of an entire class of creditors. But the cost, the expense, if you will, is something called at the bottom of this slide here, the absolute priority rule. That is, no lower class, which would include, of course, promoters and shareholders, will be able to retain any interest in the reorganized debtor. So that permits a single dissenting class of creditors to, in effect, unilaterally impose what under the IBC is the full-fledged version of 29A. That is, promoters may not retain any interest post resolution of the debt. Well, again, for small and medium-sized enterprises, indeed, the availability, the presence of the promoters may be a sine qua non of a successful reorganization. These are the people, although they may have had some financial distress, still have the connections and the insights into the operation of the business. They'll permit it to be a successful plan of reorganization. Large publicly traded corporations, for them, it is not a problem. After all, they are run by professional managers, not by the promoters, and therefore excluding the old promoters from the new reorganized enterprise is of no consequence or no fatal consequence to the successful reorganization. But with small enterprises, that is a fatal consequence. Thus, a dissenting class of creditors could essentially hold up the reorganization in order to extort or extract, if you will, even more of the benefit of the reorganizing company, and perhaps to the extent such that the promoters decide that it's not worth the price, that they will in turn turn to liquidation of the enterprise. So we advance another slide here. We'll get to our Small Business Reorganization Act that was enacted by our Congress with some prescience, which is rare to say with regard to legislative bodies, some prescience to suggest that we wanted a special provision for small businesses. So it was signed into law in August of 2019, effective propitiously with regard to essentially the beginning of the pandemic, 19 February of last year. And it enables, if you look at the middle of the slide, their existing promoters to retain ownership of the reorganized debtor, notwithstanding what we just talked about, the absolute priority rule under Section 1129 of the Bankruptcy Code. The drawback to the SBRA, as it is known, is that in its initial iteration, at least, it was designed to aid only the smallest of small businesses, that is, businesses with debts in the U.S. system of only slightly more than $2.5 million. Well, that's very small. So with regard to the first action of our Congress with regard to the pandemic, the so-called CARES Act, the debt limit for the small business reorganization provisions was increased to $7.5 million. I think most scholars and academics believe that an increase of perhaps twice that amount to $15 million would be a better solution. But in any event, it is what it is. But it's also important to note that this increase in the debt limit for small businesses under the SBRA is temporary. It will expire at the end of March of 2021. And even though our Congress passed this enormous 5,300-page piece of legislation in December of last year, tucked among that was no extension of this increase in the debt limit. So I believe that our new Congress, taking office later this month, will in fact address that. I hope it does, because it is a very great necessity at this particular time in a pandemic economy. In any event, if you could advance one more slide there, I think we can get briefly into the details of our SBRA. The details are not necessarily important for anyone in any other country. Rather, this is an instantiation of what we heard about both from the World Bank and from the econometrics people, suggesting that entrepreneurship, small businesses, are vital in the economy. How it takes place in any country, of course, will depend upon the extant insolvency law. In any event, there is a mandatory appointment of a trustee in a Small Business Reorganization Act case. This is not an operating trustee. It's not a resolution professional. Rather, it's a trustee to monitor and ensure that the debtor in possession is doing things according to the requirements of the bankruptcy law. That is, our federal administrative agency, the Office of the United States Trustee, does not have the manpower to devote a single person to overseeing each and every SBRA case. So at the expense of the debtor in possession, they must retain a court, the court will appoint a business-oriented trustee to oversee and provide advice to the small business debtor as it seeks to reorganize its debt. There will still be a plan of reorganization. The requirement of a disclosure statement is substantially truncated, and it must still be submitted to all creditors for voting. If all classes of creditors of the small business debtor vote in favor of the plan, well, then the case is done. The reorganized debtor proceeds, and whatever the terms of the plan may be will control going into the future. But if there is a dissenting class of creditors, they will no longer be able to hold up confirmation of the case as a means of extracting additional value from the reorganizing debtor. Instead, the crammed down provisions of Section 1129A are substantially modified, and the absolute priority rule is simply made non-applicable. Thus, even over the objection of a class of creditors, the promoters may retain an ownership interest, and indeed exclusive ownership interest, in the reorganized debtor. Now, the objection of a class will be taken seriously by the bankruptcy court. If the objection of a class of creditors goes to the merits of the planned reorganization itself, or the likelihood or unlikelihood of successful reorganization, a court may yet choose to reject the plan of reorganization proposed, which will probably lead to a liquidation of the small business debtor. But if the bankruptcy court is convinced that the objection of a class of creditors is simply a means of extracting additional value, that objection will be overruled, and the reorganized debtor may continue to be under the control of the original promoters. For small businesses, I think this is an absolute requirement. It is certainly a salutary development in our bankruptcy law. I hope it continues, and I hope the debt limit continues at least the $7.5 million figure, if not more. I had a final slide there with some data for cases filed in our District of Delaware. Our District of Delaware, as you may know, is home to many large publicly traded Chapter 11 bankruptcies. It is not, for that reason, a natural home, if you will, for small business debtors. They will instead file in the district in which they find themselves. Yet there are many small businesses in the small state of Delaware, and this slide demonstrates how many there were through a period of time in August, I believe, of 2019, and how many more there were as a result of the increase in the debt limit from $2.5 million to $7.5 million. So this is the Small Business Reorganization Act, subchapter 5 of our Chapter 11, is proving to be very useful and very successful. And there is a remarkable lack of litigation within the bankruptcy courts, and an even greater lack of appeals of decisions of our bankruptcy courts to higher courts, which suggests to me that both small business debtors and the creditors of small business debtors are very satisfied with how the SBRA is being applied. And in that sense, it represents a model of what other systems should do, that is to provide an expedited, less expensive, and less complicated manner to permit small businesses and hence entrepreneurs to continue into the future, notwithstanding an economic disruption, whether it is caused by the COVID-19 or by the ordinary vicissitudes of economic and business life. So any specific questions, I'd be pleased to answer if there are any later. But thank you for your time and your patience with regard to my inability to incorporate the slides into my presentation directly.
Thank you, Professor Pryor. I think that was quite exquisite. It was, we really enjoyed this presentation on the SBRA, and we are already, around 9 hours. 9
Much
hours.
later for you than for me.
Started at around 10 a.m. in the morning, and it's nearly 7:30. We just had a lunch break of around, 30 minutes or so. So in the last 9 hours, I'm sure we started with around 200 people in the morning, and still we have around 80 people who are still logged in. So I really congratulate and salute the will and the interest and the inquisitiveness of our insolvency practitioners and the participants of this conference. There are, I think, no further questions on this.
I have just one question. I don't know who is going to answer, whoever it be. We have, if you permit me, let me ask Dr. Rishabh.
Yes, please.
Yeah, no, my question is, of course, we have witnessed a lot of businesses dying down during this pandemic. A lot of businesses are, at the verge of, perishing, and some of the businesses that perished would never be revived at all. Some of the businesses have been vanished from the globe. But at the same time, did you notice some new businesses, starting, and new concepts, new business models? Maybe in smaller, humble entrepreneurship. I'm saying it's not a big business that is coming up, but still, the smaller businesses are, mushrooming throughout the globe. Maybe something related to COVID-19 pandemic, or maybe some new ideas. Professor Rebecca Parry talked about, the digital, business. New digital, businesses have started. So how do we see this, in the post pandemic time?
Well, anyone of our esteemed guests, or maybe I think the expert would be Professor Douglas Cumming, because he belongs to the business administration stream. He's not a lawyer.
Yeah,
He's a
so,
business expert.
right. So one of the unusual things, and I've done a little bit of work on this with the post-COVID data, looking at how things have evolved since COVID. And one of the things that we've seen that's a bit unusual in reference to previous times is the ability of entrepreneurs to access alternative forms of finance that haven't been around in prior years. And so one of those new forms involves crowdfunded access to finance. So, for instance, in a look at data in a recent project that we carried out, we considered how bank loans versus crowdfunded loans for entrepreneurs proceeded subsequent to the COVID crisis. In this particular project, we examined US data. And one thing that surprised us quite a bit is that we had expected initially, before we looked at the data, that the crowdfunded loans or person-to-person loans were even could be a variety of explanations for this. One of which is that we're exploring is that crowdfunded loans and bank loans are a little more complementary to one another, depending on economic conditions, and then substitutable with one another depending on economic conditions. So they offer sort of as a buffer to facilitate access to finance for new businesses during these unusual and extreme times. But this, so the sort of long, broad overview way to summarize these things is that nowadays with fintech solutions and other things, is that we have a more complicated set of things to consider, and we're looking at these extreme events like COVID, because the various types of finance that people might access are much more complicated and interrelated with one another, and it's not quite as simple as the question as a result of these new fintech innovations.
Right. Thank you, Douglas. Now, I think our World Bank expert, Antonia, would also want to throw some light on it. Antonia, are you? Can you hear us?
I can hear you. I think what we're seeing in emerging markets around the world is entrepreneurs stepping into areas that are new and emerging. So, relying on, but given the social distancing restrictions in many countries, there's been an increase on technology and services around that. So, for instance, in the US, we have something called TaskRabbit, which has really taken off because you have people in the kind of gig economy that are doing services for people who are no longer able to socialize and be in society as normal. So I do think you are seeing new businesses develop. But I also think the impact on existing businesses, and particularly what Saji mentioned, zombie businesses, is going to be significant.
Mm-hmm. Yes, although I don't have data at hand, of course, it is the case. I think that while there has been a growth in the U.S. of gig businesses, as just mentioned, those are no substitute for the small and medium-sized and even larger businesses that may face irretrievable financial disaster as a result of the pandemic. In the U.S., at least, the nature of the federal system and the money that has been made available both by Congress and the fiscal loosening by our Federal Reserve is delaying what I'm afraid will be a significant downward impact on the small business economy, for the medium and large business economy. Small businesses are indeed in trouble. They are being preserved in many cases with the largesse of their lenders, who, when faced with the alternative of liquidating a small business debtor and permitting it to limp along with the hopes that it will be able successfully to weather the COVID storm, are choosing the latter at this point. But notwithstanding the new administration coming to Washington, notwithstanding what I expect will be additional economic and fiscal stimulus, there will, I believe, in 2021 be a significant upturn in the liquidations of small businesses, unless the SBRA is continued, indeed expanded to permit them to reorganize under the bankruptcy code that we have in the U.S. So I'm perhaps not as concerned about the short term and future of small and mid-sized businesses in the U.S. economy.
Professor Rebecca?
Yeah, I think it's been mentioned in some examples that COVID has accelerated trends that would have happened anyway. One thing we've had in the UK and in many other countries is the zombie companies, which have enjoyed low levels of interest for quite a number of years and have only just been able to pay back that interest but not invest further to develop. And COVID has accelerated the decline of those businesses. They may have been able to survive for the last few months because of government support, but when that government support falls away, that's when we will see the fall of the zombie companies, but also opportunities for other companies to take their place, innovative companies, and as Douglas has mentioned, as possibly innovative sources of finance for them where they've got good ideas. Perhaps funding sources are different from those that would have been previously.
Okay, so I think I have another question, but before that, we have with us Professor Don Wallace, who's the chairman of International Law Institute. He's joined in, but I'm not sure whether he will be able to participate. He will be able to speak something. I invite you, Professor Dawn. He had kindly agreed to provide the concluding remarks. So we'll just wait for him for a few minutes. It's possible for him to join to speak something, or he can, if Professor Dawn Wallace can write something in the chat box, or if Robert Sargent is there, if you can write something, we can know that you would be able to speak something. But my question, I mean, I wouldn't say it's my question, it's my observation. Given the political stance that we have been reading regarding, at least in the US, about President Trump was unwilling to sign on that approximately $940 billion plan. Was it actually, is it actually to support the businesses, and or is it basically, to further their political agenda? To continue in that same stream, we have also read about this, the stimulus package. I think it was over $1.5 trillion stimulus package, and we read that several companies from different countries, maybe some former Soviet countries, Ukraine, and some other countries, they just created small companies in the US, and the paycheck program and different programs, they just pocketed that money, and the government had no system to ensure where that money is going. They had that money, and then you take it. So I mean, there is no check where that money is going. So the government has limited funds. So Mr. Sajid Kumar has asked a very pertinent question, that the government can provide a stimulus, but what after the stimulus ends? But my question also is, what is the intention of the government in providing that stimulus?
Mm-hmm.
And whether the planning to provide that stimulus is efficient. Because if the planning to provide that stimulus is efficient, then maybe it's a less stimulus in amount, but still it may still be effective enough.
Yes. Well, with respect to the matters relating to the illicit use of funds, the Paycheck Protection Program funds that have been identified, it is certainly the case that our federal government has no means of checking the end users, if you will, of those loans before the loans are made. Rather, the loans were channeled through our Small Business Administration, a federal agency. But the Small Business Administration itself makes very few loans. Rather, the SBA enables its small business lending to take place through local banks. It guarantees those loans. In this case, it guaranteed those loans, the paycheck protection ones, 100%. And thus, it was up to local banks, including large banks and smaller banks, to verify the business worthiness and the reality of the business of the prospective borrowers. I believe that as investigations go forward, those banks that perhaps show an unduly large number of fraudulent borrowers will find themselves in regulatory trouble, as they should. But simply given the speed with which that loan program was created by our Congress, there is simply no way to avoid some kind of fraud at the bottom end. And I do not think that should detract from the success of the program, which was very, very great indeed, and in fact has been reauthorized with additional funds by our Congress in December, and that is going forward. So why President Trump also approved some and not approved certain other bills that have come out of the Congress at the last minute, I have no way of projecting. I mean, I understand, given we not having a parliamentary system, it's we end up with bills that are passed that provide all sorts of particular benefits to the districts of the various Congress people who vote on them. So the larger amount of waste occurs in the legislation itself, not in the administration of the legislation after it is passed. And to that extent, there may have been some justifications for his actions, but I doubt, personally, based on his actions of late, especially, that was foremost in his moment. I can't explain that, but I think we can assume that in the month of February, with the new government coming into power here in the U.S., that additional funds will be made available to small businesses, and investigations will continue to be conducted for its misallocation previously, and hopefully to reduce it going forward. But those should not be in any way understood or detract from the very great success that the PPP program in particular has achieved.
Would you have any comments to make, Professor Rebecca, on this?
Yeah, I think Scott's highlighted just what was a general problem for governments as a way to get money to businesses that needed it, so that you don't have massive numbers of previously viable and successful companies all falling off a cliff because COVID happened and they lost custom. And so it was necessary to devise a way to get money to businesses, and ideally they would have done so in a way that didn't encourage chances, just trying to get the money and not having any real business idea, and also not just propping up the zombies that would fail anyway. What they did in the UK was the banks, well, they had three different levels. Some of it was direct government investment in the highest level companies, but for the remainder it was bank lending that the government would guarantee. And so there would be some role for the banks to try and work out which businesses were viable, but given the volume and given the fact that the loss wouldn't fall on them, it would fall on the government, that system may not have been ideal for achieving a balance to make sure that money goes to the right companies, but it's the best that could be achieved in the circumstances, and the circumstances are so unusual that it would always have been difficult to get things perfect.
I think Douglas is wanting to make a few comments on this.
Well, first let me apologize. I somehow lost my internet connection at home. I'm not sure how that happened. So I quickly zipped out as you were asking the question, and I've tethered my connection now through my phone to get back online. So I'm using hotspot here. So as I understand the question, how can governments directly subsidize businesses during COVID? And, these days, let me preface, I'm Canadian, definitely not American. And although I happen to be living in the US now, and crazy times here as they are, the first thing that comes to my mind, and this is something I've seen in some of the empirical projects I've done over the years, is that when you have government expenditure programs to send money to businesses, is that it becomes overly politicized, and there are just too many pressures put on folks to not make it based on economic decisions, but based on political connections amongst other things. And so, as you may have heard numerous anecdotes in the past about this. Even my spouse and co-author, Sophia Johan, she used to be the head legal counsel for a government venture capital fund. And, she too had experienced a lot of these legal pressures for making investment decisions of government money that are not strictly based on economic considerations. And so that's where inefficiencies arise. Problematic decisions get made, and so it is critical to give support to businesses and the like in times of crisis. There's a trade-off between supporting businesses and supporting individuals. A lot of people think that money should go directly to individuals and not to businesses. So that's a tricky trade-off that might help depoliticize the issue. But the more governance that can be put in place to make sure that handouts are done properly, the better off that people can be. But that's too often at least that ends up in extreme failure, as we've seen in the U.S. in this most recent handouts, the politicization of these handouts, and then likewise through other government programs that I've seen firsthand in Canada. Maybe if I just make one other really quick remark about government handouts, is that when you create government programs, and this is from the Canadian perspective, when you create government programs, it's extremely easy to create a program, but then extremely hard to get rid of the program. So these government support programs for business in Canada, for instance, have escalated over time, and it becomes a big mismatch of new programs, because creating a new program is always beneficial to the elected officials, and nobody ever wants to cancel anything, because that's a great way to get yourself unelected. So the time series path of these programs therefore escalates dramatically over time without any real strategy about the complementarities across programs and the optimal program design. So that's just sort of another caveat of creating more expenditure programs.
Thank you, all the eminent speakers. And before I invite Mr. Saji Kumar to provide his concluding remarks as the chair of the session, I would like to express my deep appreciation, in addition to certainly all the eminent speakers, but also to the participants. As I mentioned, we started at 10 a.m. in the morning. It's around 8 p.m. So we have been online since around 10 hours now. And we still have around 50 participants are still logged in, and some of them are logged in since 9:45 a.m. So that's a huge morale booster for us. So over to you, Mr. Saji Kumar.
Thank you, Dr. Garg. In fact, I don't want to take much of anybody's time. I don't want to have a concluding or summing up of this. But one thing is sure, that all of us have common problems. The problem, especially the problems of small businesses, MSMEs, the problems are similar, and the solutions are also similar. And we are all trying to help small businesses, but there are a lot of issues in this. The most important issue, or maybe difficult issue, is that a resolution, sometimes it's very difficult to even identify the assets of the MSMEs. In fact, if a professional is sent, the professional may not be in a position, the insolvency representative may not be in a position even to identify the assets. I mean, forget about the liabilities. Liabilities, are also sometimes difficult. But even the assets, what assets the MSME has, the small business has, because most of these MSMEs are kind of not so organized kind of businesses. There are legislation, requirement of incorporation or registration or whatever, but still some of these are not so organized in conducting the business. Maybe because it's a little difficult for anybody to advise them, or they are not in a position to seek proper advices of professionals while conducting the business. Most of them are individual based businesses, individual promoters, persons, maybe family business. So it lacks professional expertise to conduct the business. That could be one of the reasons why they failed. And how as regulators and as government, as academics, we would be in a position to help them. I mean, provide advice, for free. I mean, or for a nominal fee if it is possible. I think it is high time for us to think about this, and we have this responsibility. Otherwise, in times like pandemic, it's very difficult for small businesses to continue or sustain. And with this short remark, let me close here. I thank my esteemed fellow panelists. You all did a wonderful job, and those of the participants, 50 in number. I think this was really a good treat, at the close of this wonderful, symposium. Thank you, each and every one of you. Thank you once again, and I wish you a successful year ahead.
I would certainly like to thank everyone, but we just have Mr. Robert Sargent, who has joined up on behalf of ILI. Ultimately, he managed. Maybe he wants to say a couple of words.
Yes.
First of all, thank you for inviting us to join and support this important program. I'm not sure why, but we've had significant troubles connecting this morning. So on behalf of our chairman, Professor Don Wallace, and myself, we apologize for our inability to connect as you have. Secondly, we'd like to thank, on behalf of the International Law Institute, our appreciation for the wealth of information that has been shared and the international cooperation on these important matters. Professor Wallace is one of the individuals who introduced insolvency into UNCITRAL, and it would have been nice for him to have talked about the precedence of that activity and how he's fostered this through the UNCITRAL organization. This is, I think, the third or fourth insolvency program that we've conducted with India. We hope that our interactions and the cooperations that we've had over the past many months will lend to further cooperation and understanding of cross-border insolvencies, and how through these measures we can help to further support industries and businesses across the world, and to do so in a constructive and well-managed process. So on behalf of the International Law Institute, we thank you very much for this important conference.
Thank you, Robert. And again, I would like to express my deep gratitude to all our supporters. Certainly the head at the top, the Insolvency and Bankruptcy Board of India, Dr. Sahu, and we have fortunate to have all of the senior officials in all of the sessions. Deep appreciation to the Nottingham Trent University, Professor Rebecca Perry, and she very graciously have supported and asked some of her colleagues to present in this symposium, and they were very valuable presentations. To the Norman Wiggins School of Law, Raleigh University, Professor Scott Pryor, the Dean, Judge Leonard Rich, we deeply appreciate your support. We also appreciate our support to the Georgetown Law School, the Center for Transnational Business and the Law. Mr. Don D.M. was here yesterday, speaking and chairing in the session on international investment treaty arbitration. Well, this symposium was stitched together, as we all know, during the time of the pandemic, and there were some thoughts and there were some hiccups. We tried, and well, I think we managed to stitch together a good program. And as I mentioned in the inaugural session, most of the people whom we had approached, the support was there. Everybody was very positive. And again, all of this could not have been possible without the untiring support of our team. we have a team of young students, some researchers, but yes, they were tirelessly supporting throughout these last few months. The most maximum that we can give is provide them credit that we have provided. But yes, I'm sure there will be invaluable takeaways for them too from this symposium. And certainly, last but not the least, are valuable participants who are still here with us. Around 50 of them are still logged in. I really appreciate your zeal and interest in the learning process, and we assure you that we will continue with such quality symposiums for knowledge sharing and capacity building. With this, I thank one and all for joining this symposium, and I'm sure we look forward to further such symposiums.
Thank you.
Okay, thank you very much.
Thank you.
Thank you. Thank you.
Very good. Very good.